Thank you and good evening. So I think that I have the easiest of tasks. The Dean and Dr. White had to deal with the politics. I will have to stay with the law, and the law is neutral. So what we are going to do is an interpretation of the law to come out with whether or not the abortion was justified, was it legal or otherwise. So I'd like to set the tone and set the background to enable me reach a conclusion whether or not the withdrawal of the bail or the abortion or the announcement was legal. So firstly, our parliament is vested with legislative authority. So our lawmaking process, as you find in the Constitution, vests Parliament with legislative authority, and you find this in Article 93(2). And Parliament exercises this legislative power through the passage of Acts of Parliament. And these Acts of Parliament will find their way into Parliament as bills. So this, we all agree, we don't disagree on this. So I'm setting the foundation so that it will be very difficult for them to disagree with me. The next question or the next issue I hope to address is that when it comes to bails, there are different categories of bails. Not all bails are the same, and the Constitution says that, and the Supreme Court has said that. So there are ordinary bails. So bails that will ordinarily go to Parliament and go through the process of first reading right through the point of assent by the President. Then there are bails with restrictions. Bails on chieftaincy issues, bails imposing taxation, bails on questions of finance. The Constitution will place certain restrictions on how these bails are dealt with. Then we have amendment bills. It's in the Constitution. Now, in the Constitution, there are two types of amendment bills. Bills to amend entrenched provisions and bills to amend non-entrenched provisions. And the procedure for dealing with these two bills are different. And the Constitution also says that. We agree. So I'm setting them up. I need to work them up to the level when I announce my conclusion, they cannot disagree. That's exactly what I'm doing. So please work with me. But for the purposes of this discussion, our focus is on entrenched bills and how entrenched bills are treated. Now, if you look at the case of Asari and Attorney General 2015, in his dissenting opinion, this is what Justice Duche will say. The indication for me here, and I'm quoting him, is very clear. And this is that an act amending the Constitution has been put a notch higher than the passage of an ordinary bill introduced into Parliament. I'm not the one saying it. This is a Supreme Court judge. So he's saying that an act amending the Constitution is a special bill and not an ordinary bill. Now, when it comes to the processes of amending the Constitution, I like to put the processes into three main steps. The first step being what I will call the pre-parliamentary stage. And at the pre-parliamentary stage, the executive, stakeholders, students' union, CSOs, everyone can take part in this stage. This is at the stage where you can put in your manifesto that I will do this to the Constitution when I come. This is at the stage where you can decide that you will get consensus from other persons who believe in your view. So it is it is at this point, for me, the pre-parliamentary stage that you build consensus. And the pre-parliamentary stage also includes, if you look at the provisions in Article 292 to 6, also includes when the bill is introduced and given to the Speaker. Now, I make a distinction here. When the amendment bill is brought to Parliament, it is to the Speaker. Now, the Speaker of Parliament is not part of Parliament. So, I consider that as still pre-parliamentary. Why do I consider that as still pre-parliamentary? We'll see. When it's an amendment bill for an entrenched provision, it has to be referred to the Council of State for advice. So the Council of State can come back and say, add this. Why don't you consider this? Have you changed this? This can only happen at the pre-parliamentary stage. That's my opinion. Now, after we've gone back and forth between Council of State and we've done all that, and we are happy with the document, and we've garnered the necessary consensus that we need, we gazette it. So once it is gazetted, it becomes public information for all of us. Because at that point, we are asking ourselves, is this what we all agreed on and built consensus on? So once it is gazetted, after the 6 months period that the Constitution prescribes, it finds its way into the second step, which is the parliamentary stage, or what I will call the pre-referendum stage. Now, here, the Constitution is very clear and says there will be a first reading of the bill. And in relation to this bill to amend the Constitution, that first reading was done on the 28th of May, 2019. Once the bill is read, the Constitution says, Parliament shall not proceed any further. And it's clear in the Constitution, shall not proceed any further. Now, once the first reading is done, because it is a bill to amend an entrenched provision, you will need to put it to a referendum. Now, you cannot hold any public election or referenda in this country without the passage of a constitutional instrument. Now, what is this constitutional instrument? This constitutional instrument is the one that determines the referendum question. It is the document that will fix the date and fix other rules to govern the election. When this constitutional instrument is laid in Parliament, it will take 21 sitting days of Parliament for the CI to mature. My argument is that immediately the CI matures, on the 21st day, the processes for the referendum have started. And we can no longer do anything to the bill. Because we no longer have a bill, we have a CI that has taken the content of the bill, translated it into an election question, and the CI will go on to issue a writ for the referendum. So at that stage, we have ended. And the institution that can take part in the second stage is Parliament, because Parliament will do the first reading. Parliament will have to sit for the 21 days for the CI to mature. Once the CI also matures, it is my opinion that Parliament has come to a consensus that the referendum should take place. Because if Parliament's decision is to use their votes to annul the CI, so immediately Parliament says the CI has passed after us sitting for 21 days, the referendum processes kicks in. And once the referendum processes kicks in, what it means is that a new institution, a constitutional body, takes over. And that's the Electoral Commission. So then we move to my third stage, which is the referendum stage. And there you have the Electoral Commission and the CI 120 regulating the process. Now at this point, the bill is out of the hands of the executive, in my view. It's out of the hands of Parliament. It is with the CI. And the only people who can withdraw it is us at the referendum. So any withdrawal must be done at the referendum. Because if you followed my logic, I'm saying that once the CI matures, we are already in the referendum processes. Now, if we go with the argument that it is a bill and it can be withdrawn at any time, it means that the morning of the referendum, that bill can be withdrawn. And I don't think that our constitutional framers intended such a reading of our constitution. Now, I'll put this clearly, quoting Doche again, dissenting in Asari AG. He says, looking basically at the provisions of the Constitution 1992, I am of the opinion that the Constitution 1992 has been so carefully crafted as to prevent the usurpation of roles and functions of each arm of government and or constitutional body. So Doche is clearly telling us that our constitution respects this separation of powers, and even though it seems that this separation is not done the Balkan way, we must respect the roles and functions of each arm and each constitutional body. So when the CI has matured after 21 days, we cannot do a U-turn. We have set in motion a certain train that must only get to the destination. That must only get to the destination. So, was it justified? I'm saying that the withdrawal of the bill was an audacious political masterstroke with questionable legal basis. It is, and I was happy that the Dean made that statement. So it was very audacious, it is political, but when it comes to its legality and legal basis, it's questionable. I am not using the word illegal, and I am not using the word unconstitutional, because those determinations are for the Supreme Court. But I'm saying that it's of questionable. And from where I sit, and from the argument I have proffered so far, this is what I think, that its legal basis is questionable. So why is the legal basis questionable? I'll quickly give you 5 points. 1, after maturity of the referendum approval CI and the publication of the referendum writ, Parliament and the executive become functus officium. There is nothing before Parliament to be withdrawn by the executive. 2, any withdrawal or tinkering of the amendment bill can only be done before the maturity of the referendum approval CI. 3, and this is what comes back to Parliament, because I'm saying that when the CI matures, the bill leaves Parliament. What comes back to Parliament is a bill plus an approval of the people from the referendum. Together, Parliament cannot do anything but to pass it. So that which comes back to Parliament after the referendum for passage is not that old bill that left. It is a bill that has gone to the people for approval and come back. I call it the born again bill. It has gone and come back. And Parliament is restricted, and Parliament must just pass it. The withdrawal of the bill after maturity of the referendum of the referendum approval CI can only happen at the polls. We can withdraw it by voting either yes or no. Now the CI is law. It's an enactment. It takes its force from the Constitution. The withdrawal of a document cannot, in my view, kill that law. The same procedure for laying a CI, we must embark on that same procedure to revoke the CI. Otherwise, the CI, in my view, is still in force. Now, what next? I'll read a quote from the report of the Committee of Experts on the proposals for the draft Constitution of Ghana, dated July 31, 1991. I quote. It says, the fabric and essential character of the Constitution must be preserved by excluding hasty and ill-considered amendments of the fundamental provisions of the Constitution. Such changes should only occur through procedures which will ensure adequate support and desire for the changes. And adequate support and desire for the changes is only gotten at the pre-parliamentary stage. And when you have not gotten adequate support and desire for the changes, you do not put in motion the process of amending an entrenched provision. So what next? Say the matter is ripe for hearing. The Supreme Court is our best avenue to test this. And to test this so that we are able to ensure that we have clarity on this. Otherwise, today it was withdrawn 2 weeks before. The next time it might be a day before. And I don't think that any lawmaker or any enforcer of law will want the law, the fundamental law of the land, the Constitution, to be interpreted as it has been. So I go back, was the withdrawal legal? I say it was an audacious political masterstroke with questionable legal basis. Thank you.